20 years after the landmark Mabo decision, the Attorney-General Nicola Roxon has unveiled reforms to the native title system. The changes aim to make the laws more flexible and less technical to speed up a process which can take up to 15 years to settle. The reforms have been welcomed by Indigenous groups, but there's also been some disappointment that the government hasn't changed the onus of proof. This would presume traditional owners have continuous connection to land and the government must prove otherwise. I spoke to the Attorney-General earlier today. Attorney-General, welcome to the program.
Hello.
The Indigenous and legal communities have generally welcomed your reforms, but the reforms have been criticised for not going far enough. Social Justice Commissioner Mick Gooda says, given that the system is now 20 years old, bolder moves could have been made. I mean, have you missed an opportunity here?
It is an incremental reform, but it's a substantial package of reforms, and we know that there is broad support for them. It's true that people will continue to debate whether there are other reforms that should be pursued in the future, and we're open to those, but this is the package that we are determined to implement and legislate for now while we have the opportunity.
Are you considering further reforms, and how far away are these?
Well, look, we've just announced this week a package of reforms. They're the ones that I'm going to concentrate on. They do have a significant impact. This is from changing the tax treatment for native title agreements through to requiring detailed good faith negotiations and being able to speed up the process where parties agree, for example, to put aside issues of historical extinguishment or where land use agreements can be altered without having to go through a whole new registration process. They're quite a significant package of reforms. They build on the other reforms our government's already announced and in some cases already implemented. And I think that as a package, it's an important change and an important step forward in what is a long story of recognition of Indigenous rights.
If the aim is to speed up and strengthen the process, those seeking native title are spending a great deal of time proving their connection to the land. Isn't reversing the onus of proof the best way to achieve your aims?
I think it's an issue that should continue to be debated. To be honest, I don't think that sufficient work has been done to ensure that it would deliver the right outcome without any unintended consequences. But ultimately, we as a government make a judgment about which reforms can be implemented at which time. I believe we have significant support both across the community and importantly within the Parliament to introduce these reforms, and that's why I'm determined to progress them now while there's an opportunity to do so.
The Law Council has called for the Native Title Act to be further amended to empower a court to ignore evidence of a broken connection if the primary reason for the broken connection was the action of a state or territory or another person who is not Indigenous. Can you see this change happening?
What the Law Council might propose, what the Farmers Federation might propose, what each different land council might propose. There is a range of them. I think that work will need to continue to be done. We certainly as a government are not standing in the way of that. In fact, we encourage that work being done. But we do have an extensive number of reforms that have been announced this week, which we want to legislate for, and those are the ones that we will be focusing on in this immediate period.
There's a backlog of 450 claims. How do you believe the government can help expedite some of those decisions so that more Indigenous elders are still around to see a resolution on their native title?
Well, this is a crucial question. You know, when I became the Attorney-General and was briefed that it was expected that those claims might take another 30 years to be finalised, I said really that is not acceptable. That's why we announced changes in the budget to move the Native Title Tribunal into the Federal Court, to give the Court more power to move speedily for determinations, but also these changes that have been announced this week to ensure that parties, one, are required to negotiate properly, but also that will mean that more matters will be able to be settled and simply confirmed by the courts, not held up for long periods of time. So all of these changes are actually aimed to making the system quicker, to making it more efficient. Obviously, when you have to negotiate, it means parties have to be able to agree. And of course, we want to see Indigenous people being able to have that recognition of their land. But this is not something where the government or anyone else has a magic magic wand that could immediately determine all these issues tomorrow. It simply is more complex than that and not something that's possible for us to do.
The onus of proof remains hugely expensive. It generally costs $1 million for each claim just to do a connection report. I mean, is that a fair burden?
I think there are lots of questions about the costs that are involved, and of course is the reason that the government does fund significantly all of the work that's done, or a big chunk of the work that is done in establishing and bringing native title claims. I think what we have seen is an improvement over 20 years. People now know much more about how the system can work. There are quicker ways to be able to establish all sorts of facts that are relevant, but we are constantly looking at and working with the parties to see if there are ways we can speed up the process, make it cheaper, make it easier, make their agreements more effective. And Minister Macklin also announced this week a review of the way that those representative bodies work, how their funding is set out, and I imagine those issues will be dealt with in that review.
Nicola Roxon, thanks very much for joining us.
It's a pleasure.